Hello, everybody. I'm Jay Lazega. Welcome to this week's session of L&J's Morning Break. We're glad you're here, excited you're here. Hope everyone is doing well in what continues to be our coronavirus world. Today's session is on litigation issues with Pat Poe and Joanna El-Jazar. We're gonna, obviously everybody is focused these days on getting open our amenities, reopening. And we're going to talk a little bit about liability risks and tips to minimize those risks, but also in some of the normal risks we face that we have with homeowners and vendors and those types of issues that continue to plague us today, just like they did before the coronavirus issues. So that'll be the theme for today, is litigation issues. I do want your questions. If you send those, we will reach out individually and get with everybody to answer their questions afterwards. And last but not least, next week's session, we're really excited about this one. It'll be me and the infamous Jamie Lyons back in action. And we're going to be covering, hopefully, what is the last of our practical tips on the coronavirus issues, but also getting back to some semblance of the normal world we still have to deal with, that we've put on hold for a long time. Planning for meetings, annual meetings, budget planning coming up, vendor issues, normal community issues with homeowners that are violators or just nuisances. So we're going to talk about our 5 tips to getting back to the normal world next week. We hope you can join us. But today is our litigation issue with Pat and Joe, and we are going to start that now. Thanks for joining us, everybody.
Good morning. I'm Pat Poe. It's good to be here with you. Terrific to connect and have this opportunity to connect with you. I think there's a bunch of folks out there that I know. Hello. So much has changed in these recent times, and yet so much remains the same. From this perspective, I'm going to talk with you about covenant enforcement, claims against community associations, and the courts under statewide judicial emergency. First, covenant enforcements. The board has a fiduciary duty, or has fiduciary duties to the association. This remains the same. This includes fiduciary duties to enforce the declaration and rules of the community. As with collections, boards have a fiduciary obligation to enforce the governing documents, and a failure to do so can affect the value of the properties and the ability to enforce later, and can even lead to claims against board members. With this in mind, it is not advisable to stop or postpone dealing with violations of the rules or governing documents unless the violation itself is caused by the current crisis, which may be a reasonable consideration among other typical considerations. If an owner requests an exception to a particular rule or restriction, or an extension of time within which to correct the violation due to the coronavirus or other health issues, the board should give serious consideration to the request and consult with legal counsel if necessary to determine whether exceptions may or must be granted under the circumstances. However, it is not a time to simply let all the rules slide to the detriment of the community. Boards should also be prepared to conduct any required meetings and hearings remotely if possible. In sum, boards should continue to enforce the rules. Claims against the association. As many of you know, I deal with many claims against associations in addition to enforcement. Decisions by the board are and should be viewed as business decisions for the association. Such business decisions are generally upheld if the directors discharge their duties in good faith and in the best interest of the corporation, that being the association. In evaluating a board's action, the law basically asks whether the board had the opportunity to take, or had the authority, to take the action, and whether the action was reasonable. In other words, not arbitrary or capricious or in bad faith. Typically, the association is not liable for acts of members, such as members that may be violating stay-at-home rules of the state, quarantine, and such. The association is not the police. However, there is a duty to mitigate foreseeable risk, which may mean addressing circumstances that create risk. This means the association should take reasonable actions to mitigate foreseeable risk, such as closing common areas such as the pool and clubhouse, implementing rules that promote safety, and notices to members and others of potential risks. These are defensible actions. We've seen threats of lawsuits to reopen amenities, meaning members threatening to sue the association if they don't open the amenities, which must be balanced against keeping amenities closed. It's hard to imagine a judge or a jury would find fault with a board for keeping common areas closed until such time as the risk is passed. Further, what actual harm or provable damages come from not getting to use the pool? In balancing convenience versus safety, it is easier to defend a board that sides with safety over convenience. Also, boards should try to avoid attempting to be the expert deciding what is or is not safe. Instead, rely on and follow the advice of actual experts. That is a much more defensible position. In considering enforcement as well as rules in these times, follow state and local rules, expert guidelines such as the CDC, make reasonable inquiry, and rely on the advice of experts. Seek advice of the association's attorneys and use reasonable independent business judgment aimed at the benefit of the community. Doing these things will make the board's decisions defensible in this time and in essentially every circumstance. Number 3, courts. On May 4th, the Georgia Supreme Court, the Chief Justice Milton announced that he is extending for another month the statewide judicial emergency, which has been due to expire on May 13th till now. Accordingly, it will be extended until June 12th is what we anticipate. I actually heard Chief Justice speak last week, and he said his significant concern is about jury trials. They don't want to force people to come to court until it is safe to do so. Further, however, he also said that they are strongly encouraging courts to conduct business as much as possible and remotely. In fact, there's currently a proposal to allow bench trials via video conference. Essentially, the effect of the order is that courthouse doors are closed and deadlines are extended and stayed for motions and responses and discovery and even statute of limitations. Some things are moving slower, but still moving. The courthouse is closed, but not shut down. With this in mind, we're moving litigation forward when and where we can. We're filing lawsuits. We're getting lawsuits served, though it may be delayed for various reasons that, as you can imagine. We're filing motions. We're filing responses. We're filing replies. We're serving discovery. We're asking the court to set remote video conference hearings. We're asking the court to make decisions on motions that are ripe. In fact, our firm has already recently conducted default hearings successfully by a remote video conference. Video conference hearings might become a new normal, which could be a cost savings to associations. Things are working. The courthouse doors are closed, but the court is not shut down. With this in mind, even during these times, it makes sense to continue to govern our communities by enforcing the covenants, continue to make reasonable business decisions for the good of the association, and continue to use the courts as appropriate. Now to Joanna.
Thanks, Pat, and thanks to everyone for joining us today. I hope everyone's staying safe and healthy. We really miss you guys and can't wait to get back to our normal lives and see everyone again. So today I'm going to talk about 2 topics, and the first one is about vendor contracts and how they may be affected by COVID-19. So this particular topic is going to vary greatly depending on the facts and the language of the contract and the type of breach that happened. But a main concern that has been asked a lot is whether a failure to perform contract obligations is excused in light of the global pandemic. And when tackling this issue, the main defense will be what's called a force majeure defense. A force majeure defense excuses non-performance because of an act of God. And in Georgia, force majeure is both a contractual and statutory defense. So if a contract includes a force majeure clause, we would need to look at the specific language of that clause to determine whether the non-performance was excusable because of COVID-19. So, for example, some contracts will say terms like epidemic or pandemic as qualifying events. And in those circumstances, most likely non-performance because of COVID-19 would be covered. Another example of how language that would excuse non-performance would be terms of like a government order, a law, or a restriction that would be implemented that would have not allowed the performance to take place. And that, for example, would come into play with the shelter-in-place orders that have been implemented throughout the state. So in that circumstance, we would look at the contract, we would look at the shelter-in-place order at the time the breach happened, and we would want to determine if it would be covered under the force majeure clause. Now, if you're in a situation where a contract doesn't have a force majeure clause, there is still a Georgia statute that allows a party to invoke the act of God defense for non-performance. This Georgia statute, in sum, states that if a performance of a contract becomes impossible as a result of an act of God, then that non-performance would be excused. Georgia law has not specifically addressed whether pandemics or other public health outbreaks would constitute an act of God. So we can't say for sure at this time if COVID-19 will absolutely fall into that category, but we do have good reason to believe that it would be, particularly since everyone's kind of in uncharted waters and moving forward. So we would like to think that that would be a strong defense, although we can't say for sure, but we do believe that that would be something that would fall under the Georgia statute. Ultimately, when you're addressing this issue, it's going to be very fact specific. It's going to vary case by case. So if this issue does come up, please reach out to us. We will review the facts, the circumstances, the contract itself, the type of breach that happened, and the orders that were implemented at the time of the breach, and then we can analyze it accordingly. So the second topic that I'm going to quickly discuss is whether an association should notify the community if an individual has tested positive for COVID-19. So if a person has tested positive for COVID-19 and has authorized the board to fully disclose this information, then the board should notify the community and can give the person's name and positive status. This would allow any resident or community member that has been in recent contact with that individual to self-quarantine and hopefully get tested. The one thing is that we really want to urge is that boards, there are two precautions that we really encourage the boards to take before they disclose any information. First, we want to make sure that any authorized disclosure is in writing. We don't want boards giving out information based off of a person's status and their personal information due to hearsay or rumors or even an oral agreement from that person. That really should be something that's cemented in writing from the person or the person's attorney and the board that gives them the right to disclose their information. Second, we really want to limit the disclosure to the community. If, let's say, there's certain maybe vendors that were in recent contact with that individual, then that may be okay to also inform them of the person's status, but we really want to limit the board's disclosure to the members, residents, and that community, and it really should not be broadcasted outside of that. Now, what happens in a circumstance when a person is tested positive, but tells the board in confidence and doesn't authorize disclosure? The board may still have a duty then to inform the community, but of course that notice would be a little more limited. So rather than giving the person's information, they would say a resident or a community member has tested positive for COVID-19. So this still informs the community while at the same, allowing people to take extra precautions without breaching any private information of that individual without proper disclosure. But in those circumstances, we don't want the board to think that they can't just notify anyone, because we definitely want to make sure that everyone is aware of the status of the individuals in that community. And it also, in that circumstance, the board may consider wanting to contact the CDC. The CDC has the right to has more ability to get information and can tell people to quarantine themselves or contact people that were in recent contact with the individual and take other steps that they deem medically necessary. Now, if a person has not been tested positive and is just simply taking extra precaution, like self-quarantining or isolating themselves, then we don't really think the board has a duty to disclose that information, since most people are taking that precaution anyway, and there is no concrete evidence that the person tested positive or is actually diagnosed with COVID-19. This is absolutely new territory for all of us, and boards may not know how to move forward when this situation arises if a resident has tested positive. So we really encourage in those circumstances to, reach out, for the board to reach out to us to determine, the best course of action when there is a person that has tested positive. Well, thank you guys for attending. I hope this information was provided was helpful, and please continue to stay safe and healthy and take care of you guys. Take care of yourselves. We miss you guys, and hopefully we'll all be together soon. Thank you.
Thanks, Pat and Joe. The force majeure issue is an interesting one for us. The communities, we may not think about it now, but it actually works for us in two ways, or applies to us in two ways. And one is, what happens with the contracts we may have with vendors who we end up delaying because we decide to keep amenities closed for a little while, like our pool vendors? Do we still owe them the money under the contracts? And the other side of it also applies. What if we've started projects and contracts in the community, like roofing, retaining wall reconstruction, and the contractors tell us, look, we're delayed because of COVID issues, but you got to pay us anyway? Important issues for us to look at. That force majeure issue is the main legal issue that's going to decide whether or not we've got rights or obligations on those. So those are important. Okay, next week, we hope you join us for what we think is going to be a really exciting one with me and Jamie Lyons, talking about what we think are important non-COVID issues as well. And one being, one of the things I've thought about or worried about is, I think maybe the most impactful or scary thing for community associations come down the pipe in the last year, and that's whether or not the courts are even going to continue to allow us to fine based on a recent appellate court opinion in Georgia. So we'll talk about tips and issues related to that next week, and a couple of other things. We hope you guys can join us. We hope you're well. Stay safe. We miss you guys. Take care.